Hello everyone and welcome to today's webinar on ADVOs. My name is Harriet Ketley and I'm a Senior Legal Project Officer at Legal Aid New South Wales. At the outset, I acknowledge and pay my respects to the Gadigal people of the Eora Nation, who are the traditional owners and custodians on whose land we are conducting this session today. I know that a lot of you listening today work for a WDV CAS. This information should help you in your work with clients, noting that you provide legal information and not legal advice. If you have any questions about WDV CAS's practice at the end of today's session, please contact Michelle Jones in our WDV CAP unit on 9219 5791. The purpose of today's webinar is to outline some recent changes to the New South Wales Crimes, Domestic and Personal Violence Act. These changes came into effect on the 3rd of December last year. The main changes we will canvass today concern the new legal test for the granting of an apprehended domestic violence order, the sorts of conditions that a court can attach to an ADVO. The new conditions in the Act are reflected in plain English order forms, changes to the application form for ADVOs concerning family law issues, and how ADVOs can be varied and revoked. I will then outline a number of other procedural changes. Let's have a look at each of these changes in turn. The most important change concerns the test for the granting of ADVOs in Section 16 of the Act. Before this year, the test had two limbs. It required proof that the victim or person in need of a protection, and I'll use the acronym PINOP from now on, had reasonable grounds to fear and in fact feared domestic violence. This meant that the PINOP had to give sworn evidence in court that she feared the defendant would assault, intimidate or stalk her. This second subjective limb of the test was removed for certain categories of particularly vulnerable PINOPs. Children, PINOPs who were cognitively impaired, or a PINOP who had a history of domestic violence abuse from the current defendant. And this second limb has now been removed in relation to all PINOPs. And you will see in the slide in red the revision that now covers all PINOPs. This recent change allows courts to grant ADVOs for PINOPs who may be reluctant to come to court to express fears due to concerns about retaliation from an alleged perpetrator. However, and as you'll see from the next slide, without evidence of subjective fears, a court will only be able to impose the mandatory standard conditions on an ADVO. These are more limited than the broader range of additional conditions that a court can impose under Section 35 of the Act, and we will look at those conditions shortly. But first, to a key question that arises as a result of the recent changes: does a victim still need to come to court and give evidence where the respondent has not consented to the ADVO? Strictly speaking, as long as the court is satisfied that there are reasonable grounds to establish fears of domestic violence, it can now make an ADVO in the absence of the PINOP because of the new test and because of a new Section 57A of the Act. That section states that if either the PINOP or the respondent are not in court for the hearing, the court can go ahead and determine the ADVO application as long as each absent party had notice of the hearing and it's otherwise in the interests of justice to do so. However, as we've seen, where the PINOP does not come to court, the court will be restricted to imposing only the basic mandatory conditions under Section 36 of the Act. And of course, if the PINOP does not attend court, she will not have access to the WDV CAS's support and referral services and the domestic violence practitioner service lawyers. So in summary, there are now two forms of ADVOs that will be made, depending on what evidence from the PINOP is available to the court. Let's now have a look at the new conditions and see how they have changed from the former conditions. Every AVO includes 3 prohibitions to stop certain behaviour against a pin-op and their family. Defendants are prevented from assaulting or threatening a pin-op, stalking, harassing or intimidating them, and intentionally or recklessly destroying or damaging property that the pin-op owns or possesses. You will see that these conditions have been simplified and they're now drafted in more modern language. The old terms molest and otherwise interfere with in the former conditions have been removed, and there's a new standard condition, C, prohibiting a defendant from damaging or destroying any property owned or possessed by the victim. This could include, for example, property that is jointly owned, such as a TV, or even property that belongs to the defendant but is in the possession of the victim when it is damaged, such as a mobile phone. There is also a new condition in the list of additional discretionary orders in Section 35 of the Act. New Condition 35(2)(c)(1) prohibits a defendant from locating or attempting to locate the pin-op. It has been designed to address the increasing use of technology as a tool to harass and intimidate a pin-op. This condition would be appropriate, for example, where there was fears that the defendant would use GPS spyware to track the movements of the victim, or to pressure her relatives to reveal her whereabouts. There are new ADVO application forms and new ADVO order forms that reflect these changes to Sections 35 and 36 of the Act. And these changes arise out of a plain English project that has been developed to improve defendants' understanding of orders in the hope that less ADVOs will be unwittingly breached. And the Department of Justice has published a useful fact sheet about the orders, which is available on our website. Time today only permits a brief look at the structure of the new order form. It will be important to familiarise yourself with the new order structure and numbering. This is what the structure of the new application and order forms looks like. Firstly, Condition 1 will be orders about behaviour, and these are the 3 standard conditions that attach to every ADVO. Conditions 2 to 5 are orders about contact. Condition 6 concerns orders about family law and parenting. These will obviously be most relevant where there are children involved, and the ADVO may affect one party's relationship with those children. Orders 7 to 9 are about where a defendant cannot go. This could include, for example, the pin-op's workplace or her child's school. Order 10 is orders about weapons, and there's a new order about firearms, which is available, which totally prohibits the possession of firearms. And then there are other orders which can be tailored to the particular circumstances of the case. The other thing you will notice about the new order forms is that they contain examples and explanatory notes under each of the conditions about what sort of conduct would breach the condition, as well as personalised messaging to defendants about the impact of domestic violence. And just to reiterate, these additional conditions can only be made on ADVOs where the subjective limb of the test has been satisfied, unless the pin-op is a child, cognitively impaired, or has been subject to a history of domestic violence. There are other important changes to the ADVO application forms, and this next topic is particularly relevant where your client is involved in family law proceedings. When it makes an ADVO, the local court has the power to change existing parenting orders under the Commonwealth Family Law Act. In reviewing the ADVO Act, the government was concerned that this power was underutilised and made recommendations aimed at greater consistency in orders as between the family court and those made under the state ADVO regime. As a result, private applicants for an ADVO must now provide certain information about family law proceedings. And the next slide shows the extra information that a private applicant is required to provide in the order form. The first question is, are you currently involved in any legal proceedings under the Family Law Act that may be relevant? Secondly, has the court made a property order, or are property orders currently being sought under the Family Law Act? And thirdly, has the court under the Family Law Act made a parenting order that affects the current ADVO application? Applications for property recovery orders must include similar details. The next main change we will look at concerns new provisions about how ADVOs can be varied or revoked. The rules about variation differ according to, firstly, who initiated the original application, that is, whether it was police or an individual without police involvement, and secondly, whether an order covers children or not. It's important to bear in mind that under Section 38 of the Act, an order will automatically cover any children of the victim, where such children are under 18. So if a child is covered by the original order, let's look at that. Under the old provisions, an application to vary an ADVO which covered a child could only be made by police, regardless of who made the original application. Under the new provisions, if police brought the initial application, then an interested party can apply to vary or revoke an interim or final order with leave of the court. An interested party will be the PINOP or their guardian, a parent of a child covered by the order, FACS, or the defendant. The interested party must notify police, who have standing to appear to make submissions to the court about the variation application. In deciding whether to grant leave to vary, the court will consider whether there's been a significant change in circumstances since the order was made or was last varied. If the application is brought by fax, it will consider whether there's a care plan for the child that is inconsistent with the ADVO, or it will grant leave if it is otherwise in the interests of justice to do so. If the original application was brought privately, there is no leave requirement, but the court may decide to notify police and give them standing to appear in the application to vary if it considers that this is in the best interests of the child. Now looking at where there are no children on the ADVO. So in that case, if a PINOP wishes to change or revoke the order, they must first notify police if the application concerns a police-initiated ADVO. Police then have standing to appear to make submissions to the court about the variation application. Notice of the variation application must be by personal service on the officer in charge of the police station nearest to the court where the application is made. And just be aware that this is a significant change from the former Act, where a victim could apply to vary or revoke an order without police being notified or involved in the application. A court in these circumstances can vary the original order if it is satisfied that in all the circumstances it is proper to do so. And a final point worth noting here is that defendants are no longer able to apply to revoke an expired final ADVO. I will now briefly run through some other key changes to the Act. And they are, firstly, there is an expanded range of criminal offences that can be categorised as domestic violence offences. This is relevant when a court considers bail and sentencing in relation to a domestic violence offence. This expanded definition means that any offence committed with the intention to coerce, control or intimidate a PINOP will now be a domestic violence offence. Secondly, there's an expanded definition of domestic relationship to cover the relationship between a current and former partner of an individual. This means that a woman's current partner can be protected by an ADVO taken out against her ex, even if she herself is not a victim of domestic violence. Thirdly, provisional orders issued by police will no longer expire automatically after 28 days, but will last until the defendant is either in court or is served with an interim or final order, or if it is revoked or withdrawn. Another key change is that the Children's Court now has jurisdiction to make or vary AVOs during care proceedings. Police and FACS have standing to appear before any such order is made. Next, cross-examination of child witnesses in AVO proceedings by self-represented defendants is prohibited. It can take place only through a lawyer or suitable person appointed by the court, and this reflects existing practice in the local court. And finally, there's a new cost provision in the Act which expands current restrictions on cost orders against police in ADVOs. That concludes today's webinar. The final slide shows where you can go for more information about the recent changes to the ADVO scheme. If you have any specific queries, you can also phone Legal Aid's WDV CAP, and the details are provided on this slide.